it constitutes republication. And let's see, I would say then you must determine whether any added content republished the op-ed to a new audience. I could say it that way. Or I could say, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication. I could say it in that, add that to the end of that paragraph.
I think that I think that's fine if that's the court's inclination.
Do you have any objection to that?
I'm thinking. Sorry, I'm
okay.
Slow on the
one more time.
Yeah. That.
Sure. Okay. Let's see. All right. Let me see if I can incorporate it into it. Okay. So merely linking to an article does not amount to republication, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication.
I think we would prefer just to say just that first sentence. Merely linking to an article does not amount to republication, but adding content to a linked article may establish republication. Period.
Well, that's what you already had. This is
no, because we had the you must determine whether any added content that was added constitutes a republication. I think it'd be better to just delete the last two sentences than to add the sentence at the end.
Your Honor, I just want to note, I don't think that adding content is a requirement for republication. I mean, we've found a number of cases that when somebody repeats a defamatory statement, that they're as liable as the original defamer.
We're not going back. We're not going backwards. So either it's his language or my language. What do you want?
I prefer the court's language.
All right, then I'm going to put my court's language. Okay.
Do you want us to do the revisions? Because if you do it, we may have to just get it one more time from you.
Okay.
We're happy to, or
Sammy, can you do it? Okay. You gave him to Word format?
we did.
All right. Can you do that? Here.
The only other thing I would note is I think the word retransmitted in the second line is misspelled. So.
In the second line? Okay. All right, we'll take care of that. But adding content, just do it. Adding content, yeah. It's like this one right here. Two, and then just get rid of all of this and add this instead. We'll fix it, okay? All right, and we'll clean it up. We just took out the box. Okay, we'll get that done.
Okay.
All right, takes care of that one. Next one is, I think, instruction FF. Defamatory meaning, consider the publication as a whole. And we have dueling answers here. I know the defendant just has op-ed in it. The plaintiff just has it as plain, which, I mean, it does say that it means you may not seize any word, phrase, or image. So it would appear that so it could apply to both of them in that context.
The problem, Your Honor, is that we believe that because the counterclaim statements that the jury will be presented with are redacted, so the statements are in isolation, that there's a risk that as they're phrasing it, the jury may read the phrase, you must read the statements in context as a whole, to say, well, we can't do that, so therefore there's no liability. We think because it's impossible to read those statements in the context of the whole piece. And so that's number one. Number two, the op-ed was all Amber's statements. So the whole thing was her words. The counterclaim statements were Mr. Waldman's quotes in another article that we don't believe, well, that's not in evidence. So there's no point arguing about that other than you just have these one or two sentences from Mr. Waldman. So we believe that the jury's going to be confused if we give their instruction and say we cannot read it as a whole, so therefore we can't, follow the jury instruction.
Okay, I can see your point with that. Yes, sir.
I don't think there's anything in there's a lot of instructions here. I don't think there's anything that would indicate they can't find a liability if they're not able to take statements in their proper context, in the context of the entire article. Just thought it would be more appropriately phrased to be mutual, as opposed to obviously applying only to one party.
Well, because yours says you must read the statements, which is true, but you also can take the content in the context as a whole. But you can take the context of the op-ed as a whole, which is accurate. What I could do, if you want, I could keep the op-ed up top for their claim, and then for your claim, we can, in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read the statements. I could keep that in there as the second paragraph. That way they can't just pull out, because it's accurate law also, that they just can't pull out the word hoax and say, okay, this whole statement.
Agreed.
Okay?
That's fine. Thanks.
Is that okay?
That's fine in concept. I guess I would ask if Your Honor does that to add a clause saying disregarding any redactions on.
Well, it says the statements themselves, statements, in theirs you must read the statements in context as a whole.
Right. So, I think, I mean, could we say in determining whether any of Mr. Waldman's statements or whatever are false and defamatory, you must read the text of those statements as a whole. Text of those statements in context as a whole or something.
Well, that's kind of, you must read the statement in context as a whole.
You must read, can we say you must read those statements in context as a whole?
You must read those
because I just don't want
statements in
them to think
context.
that it's impossible for them to.
Any problem with just putting those instead of the?
I don't think we have a problem with that. Your Honor.
Okay. In determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read those statements in context as a whole. This means you may not seize on any one word, phrase, or image, or consider only one particular statement, phrase, or passage in isolation. Does that sound correct?
Yes.
All right, we'll add that as a second paragraph. Keep Sammy busy. All right. Takes care of that. All right, the next one I have is the objections and assertions of privilege.
Which? 32.
Oh, I'm sorry, it's Depp 32. It's a new instruction.
Yeah, right.
Yeah,
This is
you
the one
have
at the end. This is the new one.
Do you have the objection?
We do. Yeah.
Okay.
The objection, Your Honor, is that the objections made by counsel during the course of trial, we have no problem with something on that. But instructions, what they're trying to do is to direct the jury what inference to draw from Mr. Waldman's instructions not to answer.
Well, the only legal inference they can draw, they can't draw any inferences from that.
Exactly, and that's my point.
And that's what this says. You may not draw any inferences from the fact that objection was made.
Yeah, but saying sometimes attorneys stated objections during the course of this trial and instructed a witness and instructed a witness not to answer a question. Objections and instructions to witnesses are not evidence, and you may not consider them in reaching your verdict, nor are you to draw any. So, why do they need to be told this? I mean, I think this risks confusing the jury.
Because to be fair, in the depositions you wanted to keep in all those objections. When we usually would take them out, but you wanted to keep them in. So I want to make sure the jury doesn't have any improper inferences from leaving those objections in. You wanted to leave them in because show that, hey, I asked the questions, they weren't answered, fine. But you can't infer from that, oh, well, they're hiding something then, or it's attorney-client.
Understood. I mean, just like you can't infer when someone takes the fifth in a criminal case. I get that.
Right, which I would give an instruction for.
Of course, I know. I understand that. But I think that the jury is entitled to draw their own conclusions and not inferences. They're not entitled to infer anything from that. But I just think that this risks confusing the jury and getting the jury to think, if they stand up in closing and say they haven't presented any evidence that Mr. Waldman was doing this, then that's using this instruction as a sword. If they get up there and say they haven't, do you understand what I'm saying? They haven't proven that Mr. Waldman was acting as his attorney. They haven't proven that Mr. Waldman was authorized to make the statements. Then they rely on this to hide behind that. And we're not allowed, and I'm not saying that we will, but I'm not going to say, you heard him instruct him not to answer, and you should infer that he was acting as his agent. I know I'm not going to say that, but if they're going to argue in closing the converse of that, then that's prejudicial, and makes this inappropriate.
All right, yes, sir, Mr.
Your Honor,
Rose.
this is just an accurate statement of law. They chose to play about 30 minutes of Mr. Waldman being instructed not to answer. Without this instruction, that's prejudicial.
All right.
And it would also be prejudicial if they're allowed in closing to say that we haven't presented evidence of anything about the parameters of Mr. Waldman and Depp's relationship.
That doesn't follow from this instruction.
It does.
This instruction is simply saying that the jury is not to draw any inferences from the objections and instructions inserted by counsel. They can consider the evidence. They can consider whether evidence was presented or not. The instructions and objections are irrelevant to that question.
No.
All right. I understand your objections, but it is an accurate phrasing of the law. And I want to make sure that the inferences aren't taken against an attorney-client privilege.
Okay. Can you deny it over our objection?
You got it. No, I can grant it over your objection.
Sorry.
Freudian
I
slip.
meant grants. Yes, sorry.
Okay.
Can we get some direction for the arguments that they're allowed to make on closing on that, Your Honor? Because I don't think that's appropriate for them to point to a lack of evidence when they didn't allow Mr. Waldman to testify.
Pointing out that instructions are not evidence is not to say there's no connection here between these issues, Your Honor.
No, I'm not going to do that. So we're going to do Depp 32. I just need to clean up the top part of it. Okay. All right. Over objection. Be offered. All right. Then I have instruction JJ, which is the model.
Right.
So why would I not give the model?
We believe you should. I think the only looks like the only substantial difference is that they, rather than saying as it's written, it says clear and convincing evidence that Mr. Waldman's statements. It's confusing and misleading to say that if you have found by clear and convincing evidence that Mr. Waldman's statements were made by Mr. Depp, we already have a principal agent instruction.
Right. If they find principal or agent, I mean, that would be the only basis for it.
Well, first of all, Your Honor, if liability is entirely vicarious, which I think is the position of the counterclaim plaintiff in this case, I don't think there's any evidence of direct liability. If liability is entirely vicarious, then I don't think there's a basis for a punitive damages instruction at all against Mr. Depp, because vicarious liability generally doesn't result in punitive damages as to the principal. Punitive damages are only applied where the person against which punitive damages are being assessed actually engaged in conduct that was wrongful, and that's not the way they've pled and sought to prove their case. I think that's the first.
So they're saying you're not entitled to a punitive damages instruction.
Well, I disagree with that, and there's no case law that they've cited in here on that, and I think that's going backwards. That's an argument that we are, and I just think that Mr. Waldman's statements were made by Mr. Depp. I mean, I'd be okay with something that said that Mr. Waldman, while acting as an agent for Mr. Depp, made statements with knowledge. I'd be okay with that.
Is that okay?
I think we would maintain our objection on that. On the basis previously asserted, Your Honor, and then what's the other? I'm sorry, could I have counsel's language again one more time?
Sure.
Yeah, if you have found by clear and convincing evidence that Mr. Waldman, while acting as an agent for Mr. Depp, made the statements with knowledge that they were false or so recklessly, I think it's so reckless. There's a typo there, sorry. We'd be okay with that.
Yeah, I mean, we do maintain the same objection, Your Honor, the principal liability, and we do have case law for that proposition.
I'll overrule that objection. We'll go ahead and, can you type that up real quick for me?
Sure.
And get that to me. If you email it to Sammy, we can print it out.
Yep.
Okay, you're in charge of that one. Okay. All right. That's fine. I think that was it, correct, as far as?
I think it was, other than the verdict form.
Perfect. Let's go to the verdict form. Look at this. Do you have the other ones for me yet, Sammy? Or still looking?
I was typing it out.
If you can print those out.
Yeah.
All right, let me get the verdict form. All right, I think with the verdict form, it was just the first page. Am I correct with that?
In the punitive damages.
And then, well, the punitive damage, you didn't have a response, right? Do we have?
I think there was just there was a comment in what we got from them that we changed.
Okay. All right, well, in the, here. Oh, thank you. All right, I think it was in 1A, the statement was about Mr. Depp. I think the plaintiff wanted that out because we already have, the statement has a defamatory implication about Mr. Depp, and the defamatory implication was designed and intended by Ms. Hurd, which I think is.
If you look at the, I think it should track the finding instruction, which is jury instruction C on page
Okay.
4 of the jury instructions, and that's what the verdict form does.
Okay, let me take a look. And that was C, okay,
Yeah.
okay.
So the way it's been written tracks the
All
finding
right,
instruction.
tracks the finding instruction.
Yeah, we don't have a strong objection here, Your Honor. I thought it was maybe cumulative, but
It does match the finding instruction, which would be clear to the jury, so we'll keep that in.
that's fine.
And then the punitive,
And so that
So
would
on the
carry
last-
through to all of the.
oh, you withdrew all those?
We'll withdraw that, Your Honor. Their proposed language is fine.
All right, so the verdict forms as written are the verdict forms good to go, correct?
Well, are
What
you,
was-
I'm sorry, did they withdraw the punitive damages? Okay. Sorry.
So we're good with the verdict forms. What I have is the verdict forms, correct?
Your Honor, I think yes, but I do just want to make sure, and I understand we don't go back, but I just want to make sure that, for the record, we do maintain that the verdict form should state that the defamatory implication was false and not that the statement was false, because under the Pendleton case, that can, a facially true statement can still have a false defamatory implication.
And I think we had that on the record on Friday, but thanks for putting it again, it's fine. All right, so verdict forms are good. So we'll keep the verdict forms. Did you print out the other? No, you can print it out, that's how, yeah. So which ones are we missing then? We're missing which jury instructions? You're working on 2 of them, right?
32. I have 32 in FF right now.
32 and FF, and you have 1 jury instruction for me, right?
Yes, they're
All right.
editing it right now. It's JJ.
Okay, JJ is coming in, and did you do the other one yet, or no? Here, I got that one. Here, could you guys do, Michelle, or could you, on Depp 32, could you take off disputed and send that to us too?
Yes.
Thank you. And that would just leave us, we'll get those 2 printed out, and then I'll tell you the order that I'm going to do them. While I'm doing that, I do have the laptop, if both sides would like to look at the jury evidence on these. They're going to, we'll stay up here at the bench, but all we did was we put 2 files on here. There's no password for it. As soon as you open up, it doesn't have any internet, and there's just 2 files. One's plaintiff, one's defendant. They just click on those 2, and then they can watch all the audio and the video, okay? So if you want to take a look and make sure, it's been downloaded to everything that we put on our website, which is all the evidence. We didn't receive any new evidence today for audio or video files, so that it's everything on there. But if you want to take a look and make sure that everything is there, you can do that. Also, all the tangible exhibits, Jamie will have, except we need to get those other ones. So oh, you have them? Perfect.
Yes, if I may approach, I have
Okay, sure.
1301.
Okay.
And then, Your Honor, I just would like some clarification.
Sure.
I understand that Defendant's Exhibit 712 and Defendant's Exhibit 713 were initially moved into evidence in redacted format.
Correct.
Today, we offered them and put them in an unredacted form, so that's the
712A and 713A.
and then 713A.
Yeah.
I believe, Your Honor, should already have those in unredacted form. I believe that's how they were provided to you all.
Oh, they're in our binders
by-
down here?
I believe so. I will. Yes, so I believe those, you should actually have those in unredacted form
right.
from defendants.
All right, defendants.
Um,
We have a few binders down here. Hold on.
Yes, I think they would be in the binders, that's correct.
7:12 and 7:13. All right, we'll take a look at those. Yes.
So I can give you a copy. I was gonna make a proper for the ones that.
Do you want to go ahead and make a proffer now?
Yeah, but it included 7:12 and 7:13, so I can give you copies of that.
Oh, you can? Well, that would make Jamie happy since she's down here digging through binders.
Right, so I can give you copies of that right now.
Okay, perfect. All right, now we have those in evidence. Okay, so are we missing any more from over here? Or did you find out about the one that you thought was in evidence?
So, Your Honor, defendant, I believe, it's Plaintiff's Exhibit 120D. I believe actually Sammy and I had a number of back and forths about this exhibit. I believe that Defendant's Counsel provided a redacted version of that exhibit to the court, but based off of our reading of the transcript, that exhibit was not actually offered into evidence.
Okay, so it's not in evidence then?
It's not in evidence, Your Honor. I thought, and I believe I emailed it to Sammy last week.
You gotta take disputed off.
If you don't have it, I'm happy to bring it tomorrow, but it's not in evidence, so we can go back to the jury.
Okay, all right, so I just want to make sure, because it was checked off on somebody's list that it was in evidence, and I just want to make sure. I don't know, but it's not. We're good.
And then I heard the exhibits 711, A and B. I'm not sure.
No, I think
Is that
7:11 was
an
wrong.
error?
It was 7:12 and 7:13. So we're good.
All right.
So Jamie, are we missing anything else? Sammy, did you print out the ones that they sent you to? The email, did you email Sammy the?
He's just double checking right now.
Oh, okay. We'll get that in a second. Let me just put these in the order. Get that one without dispute on it. Okay, sure. Order publication. Was it in the one that I gave you? Let me see. Yeah, that stays in. Yeah, that stays in. You want to go ahead and print that out? Yeah. All right. Just print out 2 copies so we can show them. The one that Sammy printed off on republication, I'm just going to give you a copy so make sure they're right, okay?
Yes, and you should receive in your email soon, FF, JJ, and 32.
Okay. So if you print those out too, Sammy? Let's print those out. So you're sending FF also? Okay. Did you take the disputed off the top? Thank you. All right, let me just get this printed. Could you print me out another one of AA? There's a mark on this one. Or at least email that one to Sammy. Something in the paper and it just doesn't look right. Printing? Huh? I'm sorry. Can you send it to Jamie so she can print them out?
Your Honor, will we be getting just a paper printout or an electronic copy from the court?
All I have is a paper print.
Okay, so we can
So
scan it.
You can scan
Okay,
it and
that's fine.
if you want to do it electronic, that's fine.
And then will these be posted on the,
Not until after I get
not till
them.
after, okay, wasn't sure. And then they're read before closing.
They're read
so-
before closing. All right. So we have
Thank you.
that.
Okay, so I guess we just replace.
Thank you.
Okay.
If you want to take a look at that instruction and make sure it looks okay before I add it to the stack. Do you have the actual malice one? Was that sent to you? Michelle, you sent the actual malice one?
Yes.
Okay. Oh, never mind. Jamie already gave it. Sorry, Jamie.
And Your Honor, was it,
Is there?
no, I think it's fine. Does the court want to leave the, herd C, Depp 7
No.
sort of things in there? Because otherwise we could,
Oh, no, well, yeah, the numbers at top can stay. I just
Okay.
don't want to say disputed.
No, I don't think any of them say disputed.
Okay. No, the numbers, I tell the jurors to disregard the numbers in the
Okay.
heading. That's better for the record if we keep it that way. Okay, so are you still reading the publication? Okay.
Your Honor, can we get, sorry to bother Sammy, can we get one more printout of the actual malice instruction?
Sure.
Thank you.
Jamie, can we get another actual malice?
AA. So these are only copies.
All right, any objection to the republication then? As typed?
No, Your Honor.
Okay. Put that in there as well.
Hold on. I
Is
think-
there a typo?
Nope, it's okay.
It's okay?
Yep.
All right.
Your
Okay.
Honor, I just have a very quick question regarding
Sure.
closing arguments, if
sure.
we may. Does the court have any objection to us playing very small clips of,
As long as they're in evidence, you can play anything, show any picture.
well, that's my question. So
Okay.
obviously, depositions were by video, many witnesses, especially from Ms. Heard. Do you have any objection to us playing video depositions, portions
If
of?
it's not in evidence, it doesn't get.
No,
played.
of course, just what's in evidence.
But there's no video depositions in evidence.
Oh, I see what you mean. Okay, so,
The only thing that can be played to them is what is in evidence.
but their testimony, it's witness testimony.
Well, yeah, but depositions are witness testimony that you have during trial. That doesn't go back to the jury as evidence. And video depositions are the same. That would give more weight to video depositions than witness
Well, so
testimony.
my question is a follow-up question to that. Obviously, this trial was televised, so there are videos of witnesses testifying.
No,
So-
none of that comes in.
Okay,
No, the four walls of this courtroom is what the jury decides this case in,
okay.
period.
And just so we don't have a problem tomorrow, also, we can't put in front of the jury written deposition or
That's
trial
correct.
testimony.
That's correct.
Understood.
Only things that are in evidence.
Understood,
But you
Your
can
Honor.
show pictures in evidence, you can show video that's in evidence.
Or audio that's in
Or
evidence?
audio that's in evidence,
Okay.
all of that's fair game.
No,
You just-
no display of written transcripts either.
No written transcripts, just only items in evidence, and,
No, I'm on the same page.
okay, all right, just want to make sure.
Thank you, Your
And-
Honor,
and
for
you
that
have-
clarification.
And you have 2 hours, right?
Right,
2 hours each, and two people over here and 2 people over there, is that what's going to happen?
Yes, Your Honor, we're going to split our closing, and then only one of us will do the rebuttal.
Okay, and that has to just be on the rebuttal case, correct?
Right. Right,
We have that down, right? We've gone
Understood.
through that a few times.
Understood.
Mr. Chu, do you have something on that?
Yes, I just wanted to make sure we were all on the same page. So plaintiff goes first,
Correct.
then the defendant,
Does-
counterclaim plaintiff.
Right, they do
Then-
their defense to your claim, and also they do their offense to their claim.
And then plaintiff,
Plaintiff gets to do their defense to their
and they
claim and
respond
rebuttal.
only with respect to the.
Rebuttal.
To the
their-
rebuttal.
Rebuttal to their counterclaim
To the counterclaim.
only.
And so it goes 1-2, 1-2, and plaintiff gets 2 hours, they get 2 hours.
Total.
Is it fine if it's not exactly 1 hour
Oh,
for each?
that doesn't
That's
matter
up
to
to
me.
us.
No,
Okay,
as
thank
long as
you,
your
Ron.
time is just 2 hours, it doesn't matter how much anybody does.
Thank you, Ron.
Okay?
If you wanted to shorten that to about 15 minutes apiece.
I would want to short it to 2 minutes, but that's not my take. I gave you 2 hours. I thought that
We
was
got
good.
pretty efficient at the end of this
Well,
case.
it's amazing how that happens, It's kind of like the physics, you make a circle and the people will fill that circle. Well, that's what happens. I made a circle. Okay, so let's go ahead, let me just go ahead and read into the record the order that I'm going to give the jury instructions. I'll also read into the record the instructions that were denied. And I will read the instructions that were withdrawn, just so we have a complete record, okay? All right, here we go. All right, so for the jury instructions, I'll read them in the following order. Number heard I, number 3, number 10, 1, B as in boy, C as in Charlie, D as in Delta, E as in Echo, F, G, H, 12, 13, Y, FF, AA, BB, DD, that's David, DD, TT, CCC, 20, Z as in zebra, T, U, V as in Victor, K, L, 5, 6, 7, 32, 8, 9, 16, I, 30, KK, and JJ. All right, those are the ones that will be read to the jury in that order. Okay. The ones that were denied was instruction 22, 23, 24, CC, NN, both as in Nancy, OO, PP, RR, SS, S as in Sam, SS, 28 and 29 were the ones that were denied. The ones that were withdrawn, for the record, was instruction A, 2, 4, 11, 14, 15, 17, 19, 21, 25, 26, 27, X as an X-ray, 31, W, EE, GG, QQ, DDD, Q, 18, J, M, N, O, P, R, S, HH, LL, UU, VV, WW, XX, YY, ZZ, AAA, and BBB. All right. So I will get you copies now. I'll get you hand copies of the jury instructions I'm going to read in that order, so you'll have copies when you leave here, okay? And I'll give you copies of the verdict form as well. And you can have those while you prepare for your closing arguments. Other than that, if you could come up to see Jamie after I leave the bench just to make sure you go through the exhibits and everybody okays the exhibits, so we don't have to do that tomorrow. And also if you can have a look at the laptop with Sammy just to make sure all your exhibits are there that are going to go back to the jury, okay?
Your Honor, one quick question
Okay.
about closing to make sure
Sure.
we don't have any issues tomorrow. Understand the jury only sees evidence
Yes.
that they've seen in the trial. If that evidence is displayed through like a PowerPoint or whatever, are headings allowed, or do you not want the jury to see any written text or anything other than just evidence?
I mean, I've seen PowerPoints in cases before in med-mals where they have their other items up there, but I think in this particular case, I'd rather just have no writing and just have your arguments orally.
That's fine. I just wanted to, make
Okay.
sure that there wasn't
Just try to keep it clean.
or paraphrasing of witnesses or anything like
Okay,
that. It's just
that sounds fine with everybody. Does anybody?
That's fine with me.
That's a good question, though. Are you going to have a PowerPoint?
probably with evidence.
Okay.
You know.
Did you want me to have the big screen up as well for the PowerPoint?
I think
That
so.
would be
Yeah, I think that
wonderful.
would be great.
Thank you,
Okay.
Your Honor. Yes.
Okay,
Thank
good.
you.
We'll do that as well.
And starts at 9.
Starts at 9. Closings start at 9.
So Your Honor, Mr. Nadelhaft has a proffer still on some
Oh,
things.
yes,
Do
okay.
you want to do that now before we?
Sure.
As does
Yeah,
Ms.
Everybody
Myers.
wants to hear your preference.
As does Ms. Myers at the end of Mr. Nadelhoff's.
Yeah, okay. All right, they have one too, so that's all right. Go ahead.
Yeah. This will
If
be
you can just get to the microphone so I can hear you better. Or the court reporter can hear you better.
This will be shorter than the other day.
Oh, good.
Okay, this is for metadata. On May 16th and May 17th, 2022, the defendant attempted to introduce into evidence photographs from May 21st, 2016 that included metadata on the photographs. Ms. Hurd testified that the metadata was included on the photos by pressing a button on her phone. The metadata demonstrated the pictures were taken on May 21st, 2016, along with the times they were taken. The exhibits were defendant's exhibits 700 through 726 and are exhibits A through AA of the proffer. Tabs N and O of the proffer are now blank, as defendants 712 and 713 were admitted with the metadata on May 26, 2022. Mr. Depp objected to the metadata on the document, stating that the metadata was hearsay and there was no foundation for the hearsay. The court sustained the objection on the ground that the metadata was hearsay and that there was no foundation, and admitted the exhibits but redacted the metadata. And then separately, we have a proffer for Stephen Deuters. On May 20th, 2022, Ms. Hurd moved to designate certain portions of the deposition testimony for trial of Stephen Deuters, who was Mr. Depp's personal assistant. Mr. Deuters testified that he was on the Boston flight and sat in a seat facing Ms. Hurd and Mr. Depp. He further testified that the day after the flight, Mr. Depp told him he wanted to, quote, smooth whatever issue, end quote, existed with Ms. Hurd. Mr. Depp asked Mr. Deuters to, quote, write a text, end quote, to Ms. Hurd and to say, quote, whatever she needs to hear, end quote. Mr. Deuters then sent a text message to Ms. Hurd about Mr. Depp, stating, quote, when I told him he kicked you, he cried, end quote. The testimony is contained in Exhibit A, Mr. Deuters' deposition. Ms. Hurd moved to admit the text message into evidence, arguing it was not hearsay under Rule 2:803, which provides for the admission of statements of a party opponent and his agents. Ms. Hurd argued Mr. Deuters was acting as Mr. Depp's agent when he sent the text, and the text message was therefore not hearsay. The text message is Exhibit B to the proffer. Mr. Depp objected to the text message as hearsay, arguing that although Mr. Deuters was Mr. Depp's employee, sending text messages to Ms. Hurd was not within the scope of the employment. The court denied the motion to admit the text message in testimony, finding that Mr. Deuters was not acting as Mr. Depp's agent when he sent the text message. And I have copies to provide.
All right, fine. We can add it to the
list.
We have a box for you. All right, we'll add that.
Oh, sorry, Eric.
I think he has more.
And this is the other one.
All right, we'll make them part of the record. Thank you, sir.
Thank
All
you.
right, yes, Ms. Myers?
Thank you, Your Honor. On May 25th, 2022, plaintiff intended to call Dr. Kim Collins as an expert witness in forensics pathology. Defendants objected on the basis that Dr. Collins had not been designated as a defensive witness and was designated only to rebut Dr. Jordan, which was defendant's forensic pathologist who had not been put up at this trial. Dr. Collins intended to testify as to whether Ms. Hurd's descriptions of violence and injuries allegedly sustained by Mr. Depp were consistent with the photographic evidence at issue in this trial. She also, for incidents where there was no photographic evidence, she would have testified as to what injuries she would have expected to see based off of the violence that Ms. Hurd testified to. And finally, she would have testified as to her opinion as to the cause, or as to Mr. Depp's finger injury and what she observed, consistent, which was similar to what Dr. Gilbert testified to today.
All right, thank you. Any other proffers? Okay. All right, so just don't leave here until you check the laptop and you check all your evidence and make sure we get your checkbox on that and everybody's happy with it, okay? Anything else for the court?
Thank you.
Really?
No, thank you.
Thank you very much.
Thank you. Okay,
Thank you, Your Honor.
we'll see you in the morning.
All right.